Good afternoon and good morning, everyone. My name is Jürgen Kvist, and I'm the Director of Industry Practices and Procurement at the Canadian Construction Association. And I'll be your moderator for today's webinar. The Canadian Construction Association, CCA, represents over 18,000 member firms through a network of 64 local and provincial integrated partner associations. With a cross-country and cross-sectoral reach, CCA champions industry priorities such as infrastructure investment, workforce development, innovation, and best practices in construction. Our strength lies in our members through the National Advisory Councils, representing civil trade, general contractors, manufacturers, suppliers, and local construction associations. CCA ensures member voices are at the forefront of our advocacy and programming. Welcome to the second and final part of our webinar series on mastering risk management in construction. Today's session builds on a resource developed by CCA titled Mastering Risk Management in Construction Contracts, and we'll drop the link in the chat for easy access. In today's construction environment, it's becoming increasingly common to encounter non-standard agreements and supplementary conditions. While these customized contracts can help address specific product needs, they often shift more risk onto contractors and their subtrades. Contractors are generally prepared to assume additional risks, provided those risks are within their ability to control and manage. The real challenge comes with the contract push risk that contractors cannot control, which can lead to serious impact, potentially affecting their business on an enterprise level. The CCA resource is meant to be a practical guide for contractors during the bidding and contract negotiation phases. It's designed to help identify, understand, and proactively manage contractual risk, with the goal of minimizing exposure and protecting companies from significant financial consequences. With that context in mind, I'm pleased to kick off the second part of this series and introduce our panel of experts. First out, Corey Richter, President and CEO of Quarix Construction Services Ltd. Bruce Thomas, President, Ron Eastern Construction Ltd., President. Nick Willis, Regional Legal Counsel, Western Canadian Buildings at PCL. And Jessica Sidhu, Product Manager, Kinetic. And having all that said, I'll let Jessica please take the lead, and I'll share the slides. Thank you.
Thanks, Jürgen. So starting off here, we've covered a number of topics in the first part of the webinar series yesterday. Today we'll be starting off with the default notice section. As mentioned during yesterday's presentation, we are generally following the flow of CCDC and CCA contracts. So hopefully you can follow along that way. So with default notice, it's common for contracts to contain provisions that allow owners as well as contractors to suspend and terminate work in certain circumstances. However, given potential consequences of such events, it's important for contractors to ensure the circumstances in which these rights can be exercised are reasonable. For example, if the termination or suspension is for cause, you must ensure that the trigger for those rights is reasonable and that there's an appropriate cure period to give the contractor an opportunity to address the default before formal suspension or termination can be triggered. Next slide, please. There are also provisions in certain contracts for owners to suspend or terminate work for convenience. So in the case of termination or suspension for convenience or owner default, ensure that the contract allows for the contractor to recover reasonable costs. And also, where appropriate, lost overhead and profit that the contractor would have expected to earn on the terminated contract. Assignment risk should also be reviewed. In some cases, there are agreements that are assigned by default to the owner, and the process for further assignments needs to be reviewed. There may be instances of contracts continuing to be the property and the responsibility of the contractor at the time of suspension or termination. So typically, the contractor must provide notice in writing to execute further assignments that the owner should reasonably require to complete the work. The contract may require the contractor to do other work, which would be considered extra work, for the purpose of leaving the work in a safe and useful condition. So ensure that these costs are tracked costs are tracked and that they are recoverable. Next, perfect, thank you. So if an owner-directed suspension of work lasts for an extended period, ensure that the contractor is allowed a reasonable time to remobilize onto the site, as well as ensure there's a clause for equitable adjustment to the contract time and contract price to account for work being performed later than anticipated. As always, it's important to ensure if that your understanding of timeframes are correct, as in if the timeframes are in calendar days or working days. In the case of suspended or delayed work due to a court order or other public authority, the contractor has the right to terminate the agreement as well. The time frame to trigger the clause should also be reasonable. The consequence for not following through on the appropriate clauses is that a claim could be barred. So costs cannot be recovered. There may also be consequences such as consequential clauses such as liquidated damages that could impact your financials. It's also important in relation to default notice to review the terms of the notice in writing clauses. So in the CCDC 5B, that would reference Article A10. In the CCDC 2, you'd reference Article A6, for example. And with that, I'll turn it over to Bruce to talk about dispute resolution.
Hello. Some big picture comments about dispute resolution. Most contracts contain mechanisms for dispute resolution. I guess the chain in order would be negotiation is always the first form of resolving disputes. You could then have various legal processes, informal or formal mediation, binding or non-binding arbitration, and ultimately the worst of which is litigation, which would be the most expensive way to resolve a dispute. So again, I think it's important that you understand what your rights are and what processes are available to you, and how they work. I always say that what you should do is avoid this, and you should be focused on mitigation. Whenever there's a problem on a project or a dispute, it is your responsibility as a contractor or a subcontractor to take the necessary action to mitigate the impact of whatever the dispute is. So both on time and money. And if you're doing that, and also very important that you provide proper notice. So if you don't follow the mechanisms in the contract of providing proper notice and allowing for the time frames set out for dispute resolution, you're probably not going to be successful when you do go to more formal legal processes. So again, mitigate the impact, understand the process, and the nature of the dispute will probably dictate which path you follow. So just some basic ideas to make sure you're mitigating, like taking care of the risk from this perspective and understanding the process that would follow. I guess we're on to Nick.
Thanks, Bruce. So let's move on to discuss governing regulations and changes in law. So contractors should avoid assuming risks associated with changes in law because they're difficult to predict and they can have a material impact on the contractor's cost and schedule. So changes in law can take many forms. For example, imagine that 2 months into a lump sum project, the provincial government passes a new law that increases paid leave entitlements for a large portion of the contractor's workforce. This could significantly increase the contractor's cost to perform the work and result in fee erosion if the contract does not have adequate change in law relief. So therefore, changes in law should give rise to both cost and schedule relief under the contract. There are a few things that you want to look out for when reviewing changes in law clauses. So first, the clause should define change in law broadly to capture a wide variety of legal instruments. It should grant relief for changes that occur either after the effective date or whenever the contractor's price is locked in. Finally, contractors should be wary about carve-outs for any changes in law that they ought to have known about. You don't want to be fighting with an owner about whether or not you should have known about some bill that just passed second reading in the legislature but is not yet in force when you're trying to get relief for change in law. So duties, taxes, and tariffs are obviously a hot topic these days, and they are also difficult for contractors, or anyone for that matter, to predict, price, or control. It is therefore very important to ensure that you have relief somewhere in your contract for anything that arises after the date of execution. You can accomplish this in a number of ways. Perhaps the simplest is simply to build it into the change in law section by making sure that the definition of change in law is sufficiently broad to cover taxes, duties, and tariffs. You could also address it in the force majeure section of the contract, and we'll discuss those in more detail later. Or you could do it by way of a standalone clause. But however you do it, you need to be mindful of the need to establish causation. So that is how a particular duty or tariff actually impacts your scope of work, and the evidence you will need to prove that. It's not sufficient just to point to a tariff on the on the price of steel. To just generally, you need to show how that actually translates to your scope. So with that, I'll pass it back to Bruce.
Okay, so we're going to move on to talk about insurance, and it's a pretty hot topic in the construction industry these days. I'll look at it from the perspective of the types of insurance and what they are, and then the nuances around insurance and understanding the risks that come with them. The CCDC documents do a very good job laying out the various types of insurance that are the responsibility of both parties to the contract, the owner, the contractor, and/or the subcontractor. On the screen, you can see a list of various items, and there are various limits and deductibles associated with each one. In most larger projects, you will see builder's risk and wrap-up liability policies in place, usually placed by the owner. Sometimes the owner requesting the general contractor places them and effectively pull everybody together into one coverage situation. I do find it remarkable these days that a lot of owners are doing work and not truly understanding the insurance implications of the work that's going on their site, or they're relying on potentially their property insurance or other things. So I think it's first and foremost, understand which coverages are necessary for the project you're doing. Is pollution liability insurance necessary for the kind of work you're doing? So the list is there. CCDC 41 outlines all of these and usually dictates the shopping list of what will get amended in the supplemental conditions. So again, understanding what coverages are required and who is paying for them, for starters. In some regions of the country, we have other kinds of specialty coverages, particularly something like earthquake coverage. If you're in a zone out west, or even in Ottawa where we have a fault going through the city, earthquake coverage is important. Coverage for heritage buildings or potentially neighboring heritage buildings can be an issue. So understanding this up front when you're reviewing a contract, who's paying for it, what's being provided by who, what are you expected to be provided, and what would the owner be providing is important. Another thing to talk about with insurance is obviously ensuring that when you're executing work that you get valid proof of insurance from the people you're working with. And I think all of our contracts call these required documents, and we all go through processes to validate to make sure appropriate coverages are in place. If we move on to the next slide, one of the big topics in insurance and construction these days is deductibles. And truly, they have escalated significantly in the last 10 years, in particular in the last few years, because water in particular has become a massive problem. If you're doing any kind of construction at all, but particularly residential and high-rise residential, leaks are part of life on almost every high-rise residential project, and deductibles have gone from $50,000 to $250,000. On a recent project that we did, the second occurrence of a leak was going to be a $500,000 deductible. So effectively, somewhat disaster protection, because generally most incidents wouldn't make that level of damage, and therefore you're self-insuring. So understanding deductibles, and then the question becomes who's responsible for the deductibles, because if you're a plumbing contractor right now, it's very difficult bidding in the market, because if the general contractor and our owner are pushing these deductibles down to you as a responsibility, this can get very expensive. And how do you bid a project and cover your risk with these large deductibles? We see some subcontractors bidding and making notes that they won't accept large deductibles, and then that pushes back to an owner or a GC. Are they the ones covering the size of the deductible? I anticipate we're going to see more contracting clauses come in that address this deductible situation and how it's handled and the size of it and the frequency. Because if you have multiple occurrences, the deductibles get larger and larger. So pretty important that you understand when you're looking at the contracts, particularly if you're a subcontractor, are you responsible for these deductibles and what is the size of them? And how is this covered in the documents? The other thing that I think is important, and I think all of us who are in the general contracting business have been through insurance claims, is for your staff to understand the insurance claim process and how it's handled. I just went through a significant insurance claim on a project with scratch windows as a result of an EIFS contractor getting material on the windows and cleaning them with scrapers and scratching the majority of the windows on a large apartment project, and resulted in a very significant insurance claim. And, you know, how is that handled? It took almost 18 months to go through the insurance process to get to a final result so that we could get on with replacing the windows. A lot of time and effort spent on behalf of the general contractor or the construction manager dealing with this. And then obviously, you know, some costs were passed down in terms of deductibles to the at-fault contractor. But understanding the process, your insurance brokers can do a good job walking you through how that works. And I think as a risk management tool, you want to train your staff, particularly your field staff, and how to react when there is a potential claim situation. At what point do you have to notify? What are the steps to take to ensure that you're staying on side with the insurance process and protect yourself and the owners that you're working with? Pretty hot button topic right now. The deductibles are a major problem in the industry. So that's the insurance side of things. You want to go on to the next slide, which is contract security. Bonding, I think everybody's familiar with the situation with bonding. I mean, the bid bond situation is, we got an interesting situation arising in this country, and Jessica could speak to it from the British Columbia perspective, where owners are starting to attempt to contract around the Contract A, Contract B provisions that protect both sides, and they're looking for ways to avoid that provision. Again, understanding who's paying for bonds, what the expectation is. I think in the world that I live in, which is the private sector, owners tend not to bond subtrades. In the public sector, there seems to be bonding seems to be more prevalent. But again, how and when would a bonding company respond to an issue? And what are the obligations of both your field and office staff if you get into a situation where bonding is at play, and what we could expect from a bonding company? So again, assessing risk, what's bonded. We just went through a situation on a private sector job, large bankruptcy on a glazing contractor without bonds, and you have a completely different risk situation there in terms of managing without the protection of a bonding company when someone goes bankrupt. So I think the message, as we said yesterday, is read your contracts, understand what protections in place, and as important, understand how those mechanisms will respond in the event of an occurrence. That'll help you plan for the potential occurrence and know how to react in the event that they do happen. I'll pass the baton back to Nick.
Thanks, Bruce. So moving on to owner takeover. So it's important to ensure that the prerequisites for owner takeover of the project are reasonable, achievable, and within the contractor's control. This is because failure to achieve this milestone could give rise to contractual penalties, so for example, liquidated damages, or extend the contractor's warranty period, depending on the wording of the contract in question. For that reason, the contract should expressly entitle the contractor to either an extension of time or a deferral of the contractor's obligations, such as warranty, if a particular prerequisite cannot be achieved for reasons outside of the contractor's control. So early occupancy by owner. So if the contract allows for early occupancy by the owner for portions of the work, it should also expressly transfer responsibility for that portion to the owner as well. This is important in order to protect the contractor in the event that the owner or subsequent contractors cause damage to the work and seek recovery against the contractor. So for example, if you transfer a portion of a building to an owner so that a tenant fit-out contractor can commence work, and one of the tenant fit-out contractor's employees accidentally starts a fire or something of that nature, the owner could attempt to hold the original contractor liable unless the contract expressly transfers responsibility to the owner upon takeover. Pass things back to Bruce.
So it appears that we have lost Bruce there. So
No,
what we'll
hang on, Jorgen,
no,
that's
here.
my fault. That's user error. Let me try that again.
Perfect.
Push
Thank
some
you.
buttons. So we're going to talk about indemnification, claims and warranty. And I think it's important, again, read your contracts and understand what you're liable for. And basically an indemnity, owners tend to sometimes unnecessarily transfer risk through indemnifications. And the example that I wrote in my notes here is related to CCDC 5B. If you read the indemnification section in CCDC 5B related to losses suffered by owner and construction manager for which insurance is not required to be provided, and there are circumstances such as employee fraud and that are not covered by insurance, that the liability of the parties is, it states here, is the greater of the price of the work. In the case of the owner, the greater of the price of the work, or $2 million, but in no event greater than $20 million. There's a pretty large exposure there for a construction manager, particularly. You may have a fee on a job. The fee may only be a couple of $1 million, and you may be, the price of the work could be substantial. It could be $100+ million, and you could be staring down the pipe at a very large liability. We've addressed this in supplemental conditions by limiting the liability, in this case, the indemnification in this case, to potentially the fee you have on the project or some percentage of the fee. So read those clauses. I mean, the chances of there being a loss that's not insurance, covered by insurance, is probably slim because there are only certain circumstances. But understand that if that does happen, worst case scenario, your penalty here could be substantially larger than the actual fee you have even on the project, which to me is illogical. And so therefore looking to limit that liability in the indemnification clause is important. The screen mentions liquidated damages and penalties. My personal opinion about penalty clause and liquidated damages is they're ineffective without bonus clauses, and generally they can be very ineffective regardless, because they tend to put contractors in very defensive postures, and that's not necessarily healthy for a project when you're constantly defending yourself. But again, that's a discussion that you would have with owners. Make sure that any damages clauses you do agree to have proper mechanisms and procedures to for proof, and make sure you're not overcommitting to something that you might not be prepared to deal with. With regard to warranty periods, again, another read your contract moment. Make sure you're reading and understanding the warranty periods that are in your contracts. We've been involved in design build projects with 5-year warranties, and as most people know, many trades are not prepared to give 5-year, trade suppliers are not prepared to give warranties of that length. So you could be extending yourself into a self-warranting situation on behalf of your trades. So it's also important to understand the list of those things and ensure that you've done your best to pass those obligations down through all the stakeholders on the project. I'll pass back to Nick. Nick.
Thanks, Bruce. So our final category of topics relates to changes. The first one we're going to discuss is concealed conditions. Contractors should avoid clauses requiring them to accept sites on an as-is, where-is basis, including latent defects. Clauses like this are unreasonable because they push unknown condition risks almost entirely onto contractors with limited or no relief, and usually without any reasonable opportunity for the contractor to determine the true nature of any site conditions in advance of submitting a bid for the project. More appropriate risk allocation would be for owners to accept risk for pre-existing conditions and conditions which differ materially from those disclosed to the contractor at the time of bid. Force majeure relief. So in an environment of increasing volatility, it's important that contracts provide appropriate relief when circumstances arise that are beyond the control of the parties. It's commonly referred to as force majeure events. Common force majeure events include things like fires, floods, acts of terrorism, or labor unrest. So without contractual relief, unforeseen events could have pretty catastrophic impacts on contractors. So the following are some factors to consider when you're considering whether the force majeure relief in your contract is appropriate. So number one, the lists of events that will give rise to relief. This is really important. You need to make sure that it is broad enough to provide you adequate protection, because there is no such thing as a force majeure event in common law, and you will only get relief for items that are specifically listed in your contract. So number two, the degree of impact required to give rise to relief. So for example, does the clause require the contractor to be prevented from carrying out the work or just hindered? So you can imagine a situation in which a force majeure event renders a certain activity prohibitively expensive but still possible, rather than technically or rather than impossible to perform. And you want to make sure that you've got relief in either scenario. Number three, the mitigation requirements imposed on the contractor. Number four, the relief provided. So do you get time, money, or both in the event of a force majeure event? Five, whether there are any notice requirements you have to comply with to get relief. And number six, whether it is possible to terminate if a force majeure event extends for a long period of time. So our final topic is restrictions on relief. So starting with time relief. In the P3 context, many contracts unnecessarily restrict the time relief for damages available to contractors for incidents that occurred because of negligence, project co, or the contractor, even when there is insurance proceeds available. So if insurance proceeds are available, contractors should be entitled to time relief regardless of the cause of the loss. Contractors are also seeing an increasing number of supervening event clauses containing problematic carve-outs for relief. So for example, restrictions on any claims until the project schedule is approved. Caveats that a supervening event must cause a critical path delay before a time extension is granted. And time and dollar thresholds for supervening events, set on a per incident or aggregate basis, and in some cases reset annually. So restrictions like this create a real risk for contractors that is difficult to price and control. And a more appropriate allocation of risk would be to return to clauses without carve-outs and then focus on putting the parties in a no better, no worse position. We're also seeing similar restrictions outside of the P3 context. So for example, compliance with unreasonably short notice periods as a prerequisite for relief, or minimum thresholds for claims, which essentially act as a deductible in favor of the owner. So the key takeaway here is to review your contract and make sure that the relief it appears to grant is actually accessible to you in the circumstances. With that, I'll pass things back to Jorgen.
Thank Nick. Thank you to the panel. We're now getting into the question part of the panel itself. So I'm going to kick off with a little bit about the difference. And if you look at risk management and looking at the last decade as well. So a question to the panel here is, how do you see that? How has risk management in construction evolved over the past decade?
Yes, Jorgen, I'll jump in first with, I don't know that risk management's changed. I think the risks have changed. In the last few years, if you want to go back over the last, obviously the pandemic's a left turn that none of us saw coming or understood how to deal with. And now we have tariffs. So we have a couple of pretty hot button items that have changed the risk landscape. The third thing I would say is resources. And I think in my 40-year career, the last 5 to 10 years has presented more challenges with volume of work in this country, how much work we're all dealing with, retiring workforces, and that's changed the landscape in terms of risk management. And certainly we're handling things like HR much differently today than we did years ago when there was a plethora of people available. I can think back to the high-tech boom of the late 90s and early 2000s, and we snapped our fingers and the Formac guys showed up with resources like we couldn't imagine and did things in half the time we do now. So I think it's more, we know that we understand how to manage risk, but the risks have changed significantly and we've had to learn how to deal with the new risks.
Interesting. Interesting answer. Especially with the allocation of HR and resources. That's an interesting observation. Let's see. Anyone else from the panel that want to share? Jessica?
Yeah, thanks, Jürgen. And great points, Bruce. I started just over a decade ago in the office here. So thinking back to the early days and how things are managed now, all relates to the different types of delivery models as well. So the contract format, the delivery method, that's all going to have varying levels and of risk, as well as like risk allocation. We see the rise of things like, the alliance model, IPD, especially. That's the latest and greatest. And there's a different type of risk profile, and shifting our understanding of how projects are run and how resources are allocated, how risks are controlled, has varied because of that. The other one too is the requirement to have more professionals and consultants involved in projects. There's more risk. The more people you introduce, the more parties you introduce, the more likelihood of a communication breakdown. So creating additional silos has also led to having increased risks on projects. Thanks.
Great, great, angle as well, looking at the delivery methods and how they, the rules are changing and the structure is changing and no, definitely that's a interesting response. Thanks, Jessica. Okay, anyone else that wants to jump on this one before we go to the next one? Let's see, it's pretty quiet here, so we'll move on. Okay, so this one is maybe up more in the area of Nick a little bit. Maybe something, when it comes to being proactive. So the question reads as follows. What are some immediate steps that companies can take to improve their risk management practices? And I'm thinking that maybe, Nick, these are some of the messages that you share internally and so forth.
Sure, I'll take a crack at that. I think to echo what Bruce said and what we mentioned a number of times yesterday, the importance of reading your contract and making sure that everyone on the team is familiar with it is extremely important. And there's not really a substitute for that, because that is the document that will bind the parties going forward for the course of the project. And if you don't know what it says, you don't know what your rights are, you don't know what you're getting into. So that's extremely important. And it's important that happens early on, because you may have an opportunity to negotiate changes with the owner. A number of topics we discussed are things to keep an eye out for, and you don't want to miss that opportunity to mitigate risk. You might find out that you can't, come to a reasonable risk profile on a job with an owner, and so you need to make a decision as to whether or not you want to continue pursuing that project. So I think that being proactive is getting started early, getting advice if you need it, because just an ounce of prevention beats a pound of cure. It's better to avoid accepting an unreasonable risk profile than try to fight your way out of it later.
Interesting. And do you see sometimes with project managers and so forth, I've seen that there's sometimes little cheat sheets being prepared for, when you work on the work site, like these are the things that's in the contract. And do you, Nick, do you sometimes see that certain things in contracts are being overlooked, or things and rights that are in the contract that might have been forgotten about? Or how do you see those type of challenges?
Well, it's for sure. It's another thing Bruce touched on is the importance of like notice periods and claims. So it's, you want to know in advance if something's going to happen on the project, what you need to do, like what your rights are and what the process is for you to actually pursue what you're entitled to. Because otherwise, if you miss a notice period, there's a lot of case law to say that you're going to be out of luck depending on the way it's worded and the jurisdiction that you're in. And it's, you're leaving money on the table essentially. So I think it's really important to communicate that to the people who are going to be actually administering the project on the ground, and create flow charts and talk about processes and do that in advance of something happening, so you're not scrambling when you're dealing with a loss, potentially a catastrophic one, and wondering. You don't want to be looking at the contract for the first time trying to figure out what you're supposed to do.
Excellent. Thanks, Nick. I think
Jorgen,
Bruce is ready.
I'll add to that. If you want to be proactive, have a good lawyer on standby. Have a relationship with a lawyer. I've been very fortunate in my career to deal with some excellent legal minds in the city of Ottawa and learned a lot from them. But have somebody that you can talk to regularly, and that would be whoever the senior manager responsible in your organization for it. Then get that person to do a lunch and learn or some kind of a session with your project managers and the people that handle contracts, and have a really good working session to explain what we've been doing for the last 2 days, which is the key elements of reading a contract, what to look for. And then after that, encourage sharing in your office. People need to share stories of scenarios that happen, had this problem on this project, got into trouble with this subtrade, had this difficult situation. This is how we worked our way out of it. And like I said, if you've got a good relationship with a good lawyer like Nick that you got access to on a regular basis, don't be afraid to use them. A few phone calls here and there to double check are important, and then get your staff involved and share. And I think that's a mentoring process.
I agree, and I'd emphasize too that you want to do it early. Like if you end up in a dispute, often what happens if you involve council or contract management folks too late, project teams maybe take a position in a letter, on a formal basis to the owner that is inconsistent with the arguments you want to make down the road in a legal process in light of your rights under the contract. So it just pays to get people involved early rather than waiting until you're behind the 8 ball.
And go ahead, Jessica.
Sorry. Thank you. Some other immediate steps, just on the note that Nick mentioned there, are to, if you expect that there could be a claim or a potential conflict, just create a folder for it. Save your correspondence. Make sure everything is issued in writing. If you have a phone call, that phone call is no good until you're able to get that communicated in writing and there's some sort of acceptance that, it's been received. The trying to stay organized will help in the case where you do have, notice, in the case that suspension or termination needs to be initiated. So you need to be prepared, as you're going through. So hopefully you're saving some documents in a folder, thinking that it could be a problem and you're able to resolve it without it getting to that point. But at least in that case, you have prepared yourself, because the worst situation to be in as a project manager is to lose it on the opportunity to have the detailed information, have to spend, a day or multiple days going back through correspondence, trying to piece together the situation so that you're able to defend it. Another immediate step that often gets overlooked is the insurance risk. Bruce touched on the different types of insurance that we have on projects, but to understand that there are warranties that have to be upheld within each of those insurance policies. There may be practices that you have to follow. One of them is hot works permits. So there are within course of construction policies specific requirements that have to be met, and documentation that has to be compiled, kept up to date, appropriate person overseeing the process. So that's just one example, but you have to look beyond just the contract form itself. Thanks, Corey.
Yeah, you bet. So one other thing is, right in the beginning of these jobs is make it simple for yourself. So as a project manager, I see quite often where our project managers generalize the contract and they assume that the notice provisions are the same notice provisions they were in the last job and so on and so forth. So, just going through that contract, making a list so that you know what the notice provisions are, what's the form of communication. We ran into a job just last year where we sent the owner a notice of dispute, and they actually rejected the notice because the contract said that notice had to be delivered in a paper format, via courier or by hand. So, they obviously were using the contract to their advantage and they were trying to get around that. So, don't generalize the contract, just make sure you understand what the terms say. And it's as easy as just making a list for every job in terms of what those provisions are, how are they written for this job, because they're not always going to be the same. So if you do that right up front, that will make your life a lot easier down the road, especially if you get into a situation where you need to start to utilize your contract.
Very good. Thanks, Jessica. Thanks, Corey. And just looking at one of the other questions that just came in, I think you touched base on it a little bit, Jessica, about documentation about what's happening, the steps, the contract piece. This one is about risk mitigation. So I think we've all been part of the initiation of a project. You put in all your risk assumptions and so forth. So the question is really about best practice when it comes to document risk mitigation, but also to track it and actually use it in your project. So curious to see what the panel thinks about that.
Do you want me to start this time?
Yeah, that would be good. Right?
We have a number of projects where the clients require a risk register. So they ask for it in the proposal phase, and then they ask for it to be updated throughout the project. I could tell you when we started doing that, there was a lot of long faces and lips were hanging because this was another step that had to be done. But what it's done for our firm is it's proven to be a pretty valuable tool. And it can be really simple in terms of listing all the risks and what's today's mitigation. And then 3 months from now, we go back and go through that list again. Some of those mitigations change. And in some cases, the list becomes just an ongoing fluid document. So as the job is going, we're adding risks, we're taking risks off. And what we found in a lot of our meetings with the client is that becomes the focus of the discussion, is talking about the risks and how do we mitigate these and what does this mean for the client. So it doesn't need to be complicated. It can be fairly simple, and it becomes a very useful tool.
Thanks, Corey. Is there any, just as a follow-up question on that one, is there a particular frequency? Is there sort of a magic number, or are there different factors that needs to play in for the timeline?
I would say no, because it will largely depend on the style of project and how fast the project is moving. If you've got a large multi-year job, the frequency is less than if you've got maybe let's say you're doing a 6-month renovation. Well, that frequency probably has to be a lot more often because things are moving a lot quicker.
Thank you. Jessica?
Yeah, frequency wise, it should follow along with your regular reporting. If you have regular team check-ins, with the client and the consultants involved, it should be a backup document to that, something where you can pull out the pertinent ones that need to be addressed. The ideal way to track it is to keep that risk register up to date through the course of the project. We have so many different methods of addressing risks, documenting them, be it through RFIs, as the initial step to bring up that question. We've got meetings to discuss them. We've got those are regular meetings. You've got side meetings. You've got just phone calls, separate email chains. So to keep one place as a source of truth, and then again, if it's going to start becoming, dispute item or one that's a bit more complicated, and you think that you'll need to at some point highlight what strategies have been put into practice, start a file for it and save everything there. You can keep a note open, a Word document, whatever it is, Excel sheet, about what sort of written correspondence and actions have been taken. Another one, sorry for, what was my thought train here? I think I just lost it. It's all good.
Okay, yeah, we were talking about, keeping track and the frequency of follow-ups and things like that. So
thanks. Yeah, that does spark it here. So another one too is the risk register can become overwhelming. If you do have a team that's integrated fairly well and is able to go through it and pull out the ones that are pertinent at the time, that's awesome. In most cases, that's not the case. In my own experience, providing a summary of the ones that are coming due on a weekly basis is what's needed to tackle it. Not everyone's going to read a document that's 10 plus pages. So, yeah, but all the information is tracked in a single location. Thanks.
Very good. Very good. Thanks, Jessica. Okay, so we're gonna switch it up to another area, and when it comes to risk and transparency. So the question we have here is, how can construction teams, what role does transparency play in managing contractual risk? So there's always this, which information is actually available? What does party A versus party B actually know? When it comes to risks and applications like that, what is the panel's approach to that type of transparency, and why is it important in discussions?
Okay, well, I'll jump in first. So one thing on transparency, I think it depends on the contract delivery model. So if you're in a general contracting environment, GCs are a little more tight to the vest with information because they've got to manage all kinds of different risks. If in our case, we're often in CCDC 5B open book construction management situations, we're very, very transparent with our owners in terms of what we're doing and how we're managing things. I always advise my staff to first call us to the owner to tell them what's going on, regardless of whether we have a solution, because we want them to know, because the more people that know, the better chance we have to handle the situation properly. In terms of one-on-one negotiations with, say, a general contractor to a trade on the transparency front, I think it's less transparency and more cards on the table in terms of facts. What are the facts of the situation? Because the best way to solve a problem is put all the stuff on the table and try to understand both sides to come to a common resolution. So I call it more cards on the table and transparency, because what you're thinking may not be necessarily put there, but what the facts are, so you can at least come to a proper resolution, is important. So delivery method will determine the level and type of transparency in my mind.
No, that's interesting. And to your point there too, Bruce, it's like sometimes when you're in meetings and you think you got it all, this is exactly what happened. But then when you put all the cards on the table, it's, the discussion changes and the understanding gets better. So no, that's really good advice. Anyone else on that topic? No, let's see. We'll try to squeeze in, we're getting close to the end, but we're gonna squeeze in a few more questions. This is also a little bit of risk management, but and we also talked about it. This particular case, it's about IPD and contract management. So we know we went from traditional design bid build to design build to progressive design build to IPD type contracts, and maybe this is a question for Nick. How does these delivery methods influence risk and management strategies? Maybe there's a high level, when you look at a design build or a design bid build compared to an IPD, how do you look at those differently?
That's a good question. And they're as Jessica sort of alluded to earlier, to just totally different delivery models, totally different risk landscapes. Like design build, for example, like you're taking on the risk of designing the project, and that means you're coordinating with a prime consultant, possibly a number of sub-consultants and sub-consultants, depending on the nature of the project. And you as the contractor are ultimately responsible for that design to the owner. So that's a whole different scope of risk to navigate. If you are then if it's a design build, that's one animal. If it's a progressive design build, that's different, because design build, you're often submitting your price when design development is not very well advanced, perhaps 15%. One person's 15% might be different than another person's 15% design development. But if you have a progressive design build where you get the chance to work with the owner and the designers for an extended period of time to further progress the design, iron out a lot of risk, and before you submit your price, that's in some ways it's a longer process, but it's preferable from a design risk standpoint. And from an IPD or an alliance model, you're often operating in a no-fault legal environment where you are precluded from suing the owner if something happens on the project, then vice versa, subject to certain exceptions like willful misconduct or fraud, or it depends on each contract. But you know, it's a totally different ballpark, and it's often a different mindset for project teams and companies to get into when you're, you know, the traditional paradigm of a design bid build or a design build, where, you know, you're trying to hold each other accountable versus you're at the table together and you need to solve the problem in a design, in an alliance or an IPD model. It's just it's a totally different way to think. Not sure if that answers the question.
Oh, that was great. Thanks, Nick. Yeah, it definitely does. There's so many ways of doing things, and you know, even you have a design build turn into progressive design build with the the off ramps and things like that as well, which creates a different type of approach. No, very interesting. So I just get a Q&A here as well. So this is about the construction risk management. I'll see if I can read it correctly. So, do you see an industry trend of construction professionals specializing in construction risk management, or is this still viewed as a conventional project management role or something handled at the executive level?
So I think I can get started. So from at least the perspective of PCL, it sort of depends on, like, first of all, sort of everyone's responsibility, as we've alluded to, on the job, risk management. But, you know, depending on the nature and the complexity of the project and the size of the job, like, you might need some projects have dedicated legal counsel who just work on that job specifically, plus a contract risk manager. Some jobs, you know, that's not warranted. It really, and you know, bringing external resources is necessary. So I think it really depends, but it's a great question to ask yourself on each job: is what resources do we need to manage risks effectively?
So to echo what Nick said, for our organization, which is a mid-level construction manager, it starts with the executive level with me, and it's passed through to my project managers, who are all mentored to project managers and superintendents. So we don't run projects large enough to warrant a dedicated counsel or dedicated risk manager. But as Nick said, it's everybody's responsibility. Bigger the project, you may have a specialty person. Smaller companies, smaller projects, it's everybody's got to be there. So,
Jessica?
I like the addition here at the end. Is this something handled at the executive level? Definitely there are some things that have to be escalated. But as the practitioners who are putting the project execution plan together, that includes the risk analysis, including the mitigation strategies. So we're the ones leading the charge on certain issues, right? We're troubleshooting the job to make sure all barriers are removed so that the work can proceed. So for a mid-size to larger size general contractor like ourselves, we're not a national GC, but this would be part of conventional project management. But as Bruce and Nick mentioned already, having that reliance on, that outlet of legal counsel to pull specific questions to is very critical. Thanks.
Thank you, Jessica. Okay, so we're down to the last question. So this one is interesting from construction teams handling risk and kind of downloading it to subcontractors. So the question reads, how can construction teams handle risk transfer without damaging relationship with subcontractors? Let's see if there's some best practice that can be shared, how to work with trade contractors.
go ahead, Corey.
I can start. I would say that you should apply the same set of rules that you apply with an owner. As a general contractor, we always say to our owners that, the right party needs to own the right kinds of risks. So I think the same has to apply with the subcontractors. In some cases, their scope of work is such that the risk will belong with them. In some cases, as a general contractor, we may be in a better situation to manage the risk and not download it to a sub-trade. Because a lot of this all comes down to dollars and cents. So if I download too much risk to my subcontractors, they have to price that accordingly, and maybe we're not getting good value. So you know, I mean, that's kind of what we always apply is we sort of look at it to make sure, does it make sense for the subcontractor to carry that risk? You know, use piles as an example. There's lots of times where the piling guys give us this alternate price for cobblestones and boulders because they have no idea whether they're going to be present. So then as a contractor, we have to decide, so do we carry a pool of money and just deal with it based on whatever happens, or do we download that to the subcontractor? Well, if we download it to the piling guy, 9 out of 10 times he's going to carry an allowance per pile, and if he only has 1 out of 100 piles that actually has an issue, then it's a bonus for him. So yeah, you have to, as a contractor, decide what level of risk you're prepared to take and what makes the most sense to be downloaded to your subs. I don't know if that answers the question, but that's sort of how we approach it.
Thanks, Corey. Bruce, do you want to add something to that one?
No, I think he got it all. I'll go with that.
Excellent. Well done, Corey. Okay, so we're running out of time, but we just got one last question. I think I will just give a sort of a high-level answer to it. It's because of the time, but it's this question is about why certain owners favors certain models, delivery models, and in some cases shy away from collaborative models. So the question is it behavior the same from private firms? And I think a good reference is the CCDC 10, which is in the progress of being updated, is something that points out the different delivery models that you have, but it's also a combination of the risk that you take depending on which phase you're in the project. If you're in the design phase, the construction phase, etc., but also the owner's experience in construction projects will then determine which model is preferred. But then at the same time, we all know that when we get comfortable with things and it worked, why should we change it? Especially when there's millions of dollars on the table as well. So that could also be something. But we do have one more minute here if someone wants to jump in on that one, why there's why certain owners goes a certain direction.
Well, I think you're gonna. It depends on, like, public owners are constrained by the need to demonstrate visible competitiveness. So, most cities, provinces, federal government want to see lump sum bidding, so it changes the models that they use. How much collaboration is there in a GC arrangement? Well, it's kind of the jungle and we're all in it. Doing open book construction management is a difficult thing for a lot of public entities, whereas the private sector is good at it and they understand it and they can manage it. So I think it's a lot of circumstances, depends on the type of owner and the type of project.
Excellent. Thanks, Bruce. Okay, so we're at the end of the webinar, and I just want to thank you all for joining us for this important conversation on masking and risk management in construction contracts. This session marks the second and final part of our webinar series, and we hope it provided you with valuable insights and practical strategies that you can apply in your own work. As we heard today, understanding how to identify, assess, and manage contractual risk is essential to protecting your project, your teams, your organizations. And that's why the CCA's Mask and Risk Management Guide remains available as a helpful resource that you can come back and look at and share within your networks. Before we close, remember to sign up for CCA newsletters so you can stay up to date on future learning sessions, best practices, and additional resources. And on behalf of CCA and our and the staff, I really want to thank the panel for all the work that they've been putting into delivering this professional webinar with due diligence and research and collaboration discussions. So a big thank you to all of you. And on behalf of CCA and our panel, I would like to say thank you again for your time, your questions, your engagement. And we look forward to continue this conversation and supporting you in building stronger, more resilient projects. I wish everyone a great day. Thank you.